Okay, so IP, business interest, let's kind of talk about those all at once. Somewhere there's a record of your ownership of these assets. If it's a business interest, an LLC, a corporation, something like that, it's got a stock book, and the stock book says who the owners are. If it's intellectual property, you've got it registered somewhere with who the owner is. So we've got to make sure that these things get transferred into your trust. That whoever has that record of ownership knows that you want that asset to go into the trust. With LLCs, or business interests, or corporations, that's easy, because you just go and you get a stock certificate reissued. Or you do a real simple 2-sentence assignment that says, I'm assigning stock certificate number 1 into my trust. And it's in there. Intellectual property is a little harder, because you've got it registered probably 3 or 4 places. And so you usually can't go back to them and say, change your registration. The best thing to do there is to do an assignment that very specifically says you're assigning all your intellectual property rights in whatever it is into the trust. So these, we usually don't worry about these because we can usually deal with those pretty quickly if we know about them. It's one of the other things is attorneys will ask you questions about assets that are generally around, but they're not always going to ask about some things like intellectual property and copyrights and patents and things like that. So when you make your list of assets and you put that down, that's going to trigger the attorney to know that you got to deal with this. You got to keep it out of program. Receivables is a very hard one. How many people have loaned money to a family member? How many people got it in writing that the family member was going to pay you back? Okay, so you did. Good. All right. Those receivables are really important because if your trustee doesn't know about them, if you don't have a writing, if there's no thing to tell the trustee this person owes you money, they're never going to collect it. They're never going to be able to. If you did a note, it's probably a really simple note that just says, I'm lending to my nephew $25,000, he's going to pay me back. But it's I. It's not your trust lending the money, or you're not saying, I want you to pay my trust back. You're saying, I want you to pay me back. That's a perfect thing to end up in a probate court, because if the nephew hasn't been paying and doesn't want to pay, then the nephew's just going to say, well, you're dead. I've never told me to pay anybody else. So these are really tricky. We do them all the time, and we never really think through who's loaning the money and who's supposed to get paid back. So if you did some paperwork on that, check it. Especially if it's money you actually want to get paid back. It's the other, yeah.
And by the way, every other family member will know you lent that money.
Right. So even though we all will know it, we can't enforce it because there's nothing right. Yeah, so everybody just gets unhappy with you because you weren't fair. Okay, so receivables, foreign assets are very tricky. The only thing I say about foreign assets is that in certain circumstances, the IRS will put them into your gross estate. If these assets cause you to pay a tax in the other country, and that country has a treaty with the U.S., you're not going to pay any more estate tax. The IRS is going to give you a credit for what you paid in the other country. Beyond that, if you've got foreign assets, you really should talk to an attorney to make sure that you've got a treaty like that, or you've done some other things to make sure that that it works that way.
And again, if you have foreign assets and you want to go to an attorney who has experience dealing with foreign assets.
Okay, so cars, we never put cars in the trust. It's a real practical answer. If I crash into somebody and they see my registration and it says trust, it's about 150 times more likely that their neck hurts than if I crash into my name in State Farm. So we never put cars in there. The DMV makes it really easy. They have a half-page form that tells you how you're going to transfer title. So it's not a hard thing to deal with. It's not going to cause you to go to a court.
What about boats, Mark?
Boats. Okay, boats that depend on if they're DMV registered or Coast Guard registered. Their registration's somewhere, and we have to figure it out. If it's DMV, not so bad. If it's a Coast Guard registered boat, we've got to assign that boat by hull number into your trust. And then the Coast Guard will let it go according to the terms of the trust that we're going to eventually create. it's still going to be in your gross estate no matter where it is. But the ownership, that's how ownership is. If there's two cars that are worth more than $100,000, could you go over the $100,000 limit? Technical answer is yes. The practical answer is we draft our trusts so that there's actually a gift of automobiles to the specific people. And we tell the executor of the will, if you've actually got the cars, we want you to make this gift, so that we're not claiming it just by that $100,000. We've actually got an instruction that leaves it to them.
Yeah. Your fiduciary or your successor trustee will take care of that car and not report it. You didn't hear that, Mark.
Okay, so real estate. You know the county that the property is in is going to have a title. It's going to have a record of title. You've got to make sure that in that record of title, it's in your trust. In California, that's easy. In other states, it can be tricky because the rules in California say you can take your property and put it into your own trust. It's not a gift. There's no income tax implications. There's no property tax reassessments. It's a pretty easy thing.
Mark, what I see a lot is people who have a small parcel of property in another state and they don't think it's much of value, you know, $5,000 maybe value of a property in another state. That property could cost you an enormous sum of money trying to get it through probate because it has to go through probate in that state. So if you have any property, make sure it's listed and titled in your own trust. It's a common error.
I have a client who decided to buy up a bunch of pieces of land in New Orleans after Katrina because he thought it was a good investment. And then he died. And now he's got 7 pieces of property that are in his name in Louisiana where they have the strangest civil law I've ever come across. And it's probably going to cost us $50,000 or $60,000 to get these pieces of property in. And they maybe are worth $5,000 a piece. And so his family is now thinking, well, just let the property sit there. And eventually it'll get flooded and wiped away or something like that. The trick is you want these Louisiana properties in your trust. There are companies called U.S. Deeds and another one called U Deeds. You go online, you tell them the parcel number of the property, and they will do the deeds. They will guarantee the deeds, and they'll charge you $200 a deed. That's a heck of a lot cheaper than the $50,000 or $60,000 that we're...
Yeah. Another one that's commonly is mobile homes. If you own a mobile home somewhere in the mountains or somewhere else, they also are either vehicle DMV or sometimes through HUD. So just make sure how you have your assets titled. DMV is very easy to deal with now with cars. You know, if you're a married couple, do John or Mary. Or. That way you don't even have to go to the DMV.
The Auto Club will do all of this for you.
Yes.
And if you ever get into the situation, it's almost, and you're not an Auto Club member, it's worth joining the Auto Club just to let them deal with this for you.
Yeah, it's really easy.
So Hegstead, okay, so Hegstead is Heggsted. What happened in Hegstead was the guy who did this created a trust, put all his assets into the trust, had a pour-over will that said I wanted to go into the trust, and then had a general assignment, like Pete was mentioning before, that said I want all my assets to go in the trust. And it was a piece of real estate, and I don't remember exactly what happened, but it somehow fell out of the trust, most likely because of a refinance. Because you refinance your property, escrow companies take it out of the trust as part of that, and they never put it back in. Although they tell you they're going to, they don't. So I think that's what happened in this case. But what the court said was, well, hey, even if we go through the probate process, which is a 10, 12, 13-month process, we know where we're going to end up. We've got a will that says put it in the trust. We've got a general assignment that says I want everything to go into my trust. So instead of having to go through the full-blown probate, we can go through a shorter process that ends up with a court order saying that asset should be in the trust. So back to the tax. We'll go through the rest of the tax pretty quick because it's easy. The IRS is the first thing we do is get a picture of your gross estate. Now the IRS is nice for 2 moves. They'll tell you anything you leave to your spouse, dollar for dollar, unlimited amount, up to 100% of what you own, can go to your spouse, and it's deducted from your gross estate as marital deduction. Same thing, dollar for dollar, anything that you leave to a charity is deducted from your gross estate. So, if I have a gross estate up here that's $5 million, which is, oops, that's a 5, and I leave it all to my spouse, what's down here in my taxable estate?
0.
Yep. If I have $5 million and I leave $5 million to my spouse, oh wait, I did that wrong. Let's say I have $25 million and I leave $5 million to my spouse and $20 million to charity. What's in my taxable estate for the IRS to tax? 0. So these are really the most important things that we can think about when we design a trust. The third thing we have to think about is, once we know it's taxable, the IRS applies its tax rates. Right now, 45% of every dollar that's in my taxable estate is going to get hit with the estate tax. It's an awfully big tax. 2 years ago, though, it was 55%. So it's going down, but
Oh, it's 35. 30.
we're getting to 35. Yep. Since 2001, these rules of these numbers, this number has changed. Well, we're not there yet. There's a number down here that has changed basically every year. The tax rate has changed basically every year. And we're in one of those 2 years where it's changing again. This is where we hope to get. Once we know what our taxable estate is, we apply our tax rates. That gives us our tentative tax. Our tentative taxes before our credit. Remember, you know how everybody has a credit, standard deduction on the income taxes that you can use, and then you've got charitable deductions on the same thing on the gross estate. Here you've got this credit. And it's changed terms over the years. We just keep calling it credit. It's been called an exemption amount, an exemption equivalent amount, an exclusion amount, all sorts of things, but it's basically credit.
And what is it this year?
This year, if I had left this at $5 million, and we didn't leave anything to my spouse or anything to charity, and I had a taxable estate at $5 million, my credit is going to pay the tax on $5 million. The credit's $1,840,000 some dollar figure like that, but the bottom line is it's the exact amount of tax as if the $5 million got applied. I mean, the tax rate's got applied to the $5 million. It's not 45% because they're progressive rates, so it doesn't work out identically like that. But my credit pays the tax on $5 million. Now, these assets up here, I can only leave them to my spouse, right? That's what the marital deduction says. The charitable deduction, I can only leave them to charity. But this credit, I can leave to anybody I want. And so these are the three things that we look at when we design an estate plan and we design a trust, so that we know how much do we want to leave to a spouse, how much do we want to leave to charity, and what are we going to leave to other people.
So are you saying that I have to have a net worth, if I'm a single individual, of over $5 million in order for me to pay an estate and gift tax?
That's true. Now that number's changing. So what Peter just said is if you're single, you have to have an estate, that gross estate that we looked at, of over $5 million before you have to worry about an estate tax.
That's net, not just a gross, right?
Right, on this it's net. So you deduct your mortgage, you deduct your whatever you owe on your cars, you deduct all those things to come up with this.
So it's a net worth. For estate and gift tax purposes, you need to know your net worth. It's over $5 million, you're going to be paying a tax. Under, no tax.
No tax. Now this number has been changing for, like I say, since 2001. Way back then, this credit protected $675,000. And there was the Bush era tax cuts, which jumped this up to $1 million, and then $1.5 million, and then $2 million, and then $3.5 million. And we ended up with 2010 where there was no estate tax. We thought.